Well, going back to my speeding example for appellants, in the rule you're saying basically that the officer who shot the radar gun and wrote down the ticket wouldn't have to testify in the speeding ticket case? That his sergeant could come in and testify, say, I know how to operate a radar gun, and that's what the result was, so he was speeding, or she was speeding?
No, Your Honor, there are additional issues in your scenario. The additional issues in your scenario are that the officer on a speeding traffic ticket, first of all, I don't believe there's a printout on the radar gun, although he does transcribe it to the ticket. But the officer who does that speeding ticket is effectively a wheel witness, or the equivalent of a wheel witness, in a DWI intoxication case. And that's exactly why, as the record reflects in that note 2 that the petitioner referred to, 3 out of 4 of the people in the chain of custody in this case were brought forward. Officer Waters came forward, the nurse that took the blood draw came forward, and Mr. Harbor came forward. And as Melendez-Diaz said in 2009, and I quote, "We do not hold, and it is not the case, that anyone whose testimony may be relevant in establishing the authenticity of the sample or the accuracy of the testing device must appear in person as part of the prosecution case. Gaps in the chain go to the weight of the evidence rather than its admissibility." And that's why it's important, Your Honor. It's the weight of the evidence. And the jury in this case, as reflected in the testimony of Mr. Harbor and that answer on page 38 that he had no personal knowledge of the procedures being followed, the jury had the opportunity to consider that and what kind of weight they gave this evidence. But as Your Honor also noted earlier, Judge Hine, 49.04 of the Texas Penal Code, the DWI statute, provides for 3 ways to prove intoxication. Degradation of mental faculties, physical faculties, or the blood test. And a principal issue in voir dire is that anybody who requires a blood test is struck if they are not able to follow the other 2 provisions.
Is that in our record that juror or veneerman who would require a blood alcohol test was struck for cause, or by peremptory?
No, Your Honor, it's not in the record, but it's common procedure in prosecutions under DWIs that is a question that's asked in voir dires, whether or not you can follow the law. And the law in Texas, as you stated earlier, Judge Hine, is that there are 3 options for proving that intoxication. Now, as to my second point.
Before you get off that, if you did not have the mechanical test result, what evidence would be lacking? What is the need for that?
Your Honor, honestly, there is no evidence lacking without the raw data, although there's nothing that should keep the raw data out. There was evidence on page 2 of the record that Officer Waters, on coming upon this accident scene, where Miss Herbster swerved from what she described as a red-nosed deer coming home from a Christmas party on December 24, 2009, she crashes into a ditch. Officer Waters arrives on the scene and immediately notices signs of intoxication. Slurred speech, glassy eyes, watery eyes, strong odor of alcohol in her breath. He gives her the standardized field sobriety test, and she fails them all. Now that is not in my opinion, but rather in her counsel's opinion, as reflected on page 36 of the record, overwhelming evidence of her guilt.
Maybe of the fact of intoxication, but the degree of intoxication, is there any other evidence other than your machine?
The degree of intoxication, Your Honor, yes, the evidence would be those standardized field sobriety tests. Now, as to my second point, even if the report itself is testimonial, the data and the testimony of Dr. Harbor were properly admitted. And for this, we go back to State v. Bullcoming out of New Mexico, in which, again, they found the report was testimonial, which we disagree with. But they said, and relied on Melendez-Diaz, that an expert can still testify if he's not the individual who conducted the test. And the raw data itself can still come in. And that's exactly what happened in United States v. Washington, the case that we discussed earlier out of the 4th Circuit, that was denied cert. It was an expert. The importance there was that the defendant have somebody to cross-examine about the procedures, whether or not it was the analyst or somebody else, merely, as Melendez-Diaz stated, went to the weight of the evidence. Now, also of principal importance in that Melendez-Diaz case was the fact that the decision stated that there is one classification of people that routinely come in, and that's clerks. People who do not have any sort of judgment on what they're relaying, the information they're relaying, or creation or interpretation of what they're certifying, but they're merely certifying something. And that's what Ms. Lindsay did here. She merely certified the raw data.
But counsel, there's comments in the record that she was having mental problems. That's vague, but she's on sick leave apparently, and that she was romantically involved with the fellow who did testify. So doesn't that at least raise a question about whether or not there's a possibility that she indicated some of that results in error?
Your Honor, while it raises the possibility, again, that would go to the weight of the evidence, as Melendez-Diaz stated, not the admissibility.
What if she wrote the numbers down?
Your Honor, that's a risk, even in United States versus Washington, United States versus Darden. That's always a risk. And that's something that the jury would evaluate, again, in that answer on page 30 of the record, where he said Mr. Harbor said he had no personal knowledge of the procedures.
Well, but how then can defense counsel test the accuracy of the scrivening if they can't cross-examine the person doing the writing?
How can defense counsel address that, Your
How
Honor?
can they test the accuracy of what the acts she did in writing that stuff down? The witness isn't there for them to cross-examine.
I'm almost out of time, Your Honor. May I briefly answer your question and conclude?
Yes.
The way to test that is exactly the way that Mr. Herbster tested it. To make an issue out of it, bring it up, as he said, you have no personal knowledge of it, and allow the jury to weigh that into their considerations of the evidence. And that it was why Mr. Herbster appropriately acted in this case, and it's also an example of why he was not ineffective. For these reasons, we respectfully request this court affirm the 15th Court of Appeals.